You've just set up a brand new living trust and you're wondering what assets should go in the trust. Do I just put everything in the trust? Well, the truth is there's some assets that work great in a trust and there's some that you're better off leaving out of the trust. So we're going to talk about which assets go in your trust and which ones you might be better off leaving out of your trust. Hi, I'm estate planning attorney Mike Smith with Smith Barid LLC, and I'm one half of the estate planning guys. So establishing a trust is essential for bypassing probate and ensuring that your assets are smoothly transferred to your loved ones when you pass away. It's also a great way to plan for incapacity, which is a cognitive impairment, such as the result of a stroke or dementia, where you can't manage your own affairs anymore. A living trust is really just a bucket that you put your assets into, and as long as you're alive and you're competent, in other words, you have your marbles about you, then you're holding the handle to the bucket, and you can do whatever you want to with the assets that are in the bucket. But if you become incapacitated, so if you suffered a stroke or developed dementia, for example, the person that you've chosen can take over the handle to the bucket and manage all the assets without having to go through any kind of conservatorship or guardianship proceeding in a probate court. And when you die, unfortunately, that's one thing that's going to happen. We're all going to die. So we want to plan for that. And with a living trust, when you die, your estate doesn't have to go through probate as long as you've got your assets in that trust bucket. So most assets you're going to want to put into the bucket. There's a few that you might want to leave out for various reasons. So we're going to talk through what those are. And it's crucial that you know which assets to include and which ones to leave out. So we're going to go over some examples and explore what the considerations are. First, let's talk about retirement accounts. So these are qualified accounts like IRAs and 401ks, 403bs, etc. It's generally not advised to place these in a trust. And obviously, if they're qualified plans, then they qualify for certain special tax treatment because of the way they're structured. And we can't put them in a trust because we're going to mess up that structure. So you think about an IRA. IRA is short for individual retirement account. So if we put it into a trust, it's not your individual account anymore, and it's not entitled to that tax deferred treatment that it gets as a retirement account. So you don't want to, quote, put a 401k or an IRA into a trust. However, if you have concerns about the beneficiaries and their ability to manage money, there are ways that you can use a trust to control the flow of distributions out of the IRA or 401k. And there can be some tax implications to that. So you're going to want to explore that in full before you make the decision. I have found that oftentimes there are considerations beyond taxes. So for example, if you have a beneficiary who has special needs, that would be one key type of situation where you would want to name the trust as a beneficiary rather than that special needs loved one. And there could be examples where a beneficiary is profligate in their spending, so they're a spendthrift. They don't maintain good control over their spending habits. That could be a situation where it's more important to protect the beneficiary and protect the assets for their use than it is to get a tax benefit. And so you may consider using a trust as the beneficiary of a qualified account in that type of situation. So those are some examples of times when you might want to name a trust as a beneficiary of a qualified plan rather than naming the intended beneficiary directly. Now, let's talk about life insurance policies for a minute. I think that those are totally appropriate to put inside of your trust. Sometimes if you have the potential for an estate tax issue, we might use something called an irrevocable life insurance trust. You might hear it referred to as an ILIT to hold the life insurance policies. But if we don't have those estate tax issues or concerns, then we can put them in that bucket. Why would we want to do that? Well, if you become incapacitated, if the insurance policy is in the bucket, then the trustee will have control over the insurance policy. And that means that they could use the cash, if it's a whole life or other kind of permanent policy, they could use the cash from the policy to do things like pay for your medical care, for example, if you needed to be in a nursing home or an assisted living facility. Likewise, they could update and change beneficiaries if that were necessary, because maybe there was a beneficiary that you had named for the life insurance policy and they've passed away and you're incapacitated now, so you're not going to be making those changes, the trustee would be able to make those changes. So if you're interested in learning more about how we help families protect their legacies from probate, predators, and government intrusions, I wrote a free book titled The Ultimate Gift that lays it all out. If you'd like to pick up your free copy of The Ultimate Gift, simply click the link below, give us your address and a credit card for shipping and handling fees, and we'll ship it out to you free of charge. Read The Ultimate Gift so you can learn how to protect your family. And the other thing about a life insurance policy is if the trust is the owner and the beneficiary of the policy, then your trust will control the flow of the assets, the flow of the death benefits from the life insurance policy after you pass away. So you can direct how those are distributed out to the beneficiaries. So if you have, again, a beneficiary who just, is not good with money, then you can control the distributions to that beneficiary of the life insurance policy benefits through the trust document itself. So that can be a great way to maintain some control over those assets. So life insurance policies, generally you're going to want to put those inside of the trust or into an irrevocable life insurance trust if you need to get those policies out of your estate. Now, let's talk for a minute about jointly owned accounts. Those are great to go in the trust if you're setting up a married joint trust. So if you're married and you're setting up a joint trust together, you can just move those accounts into the trust. There are no tax implications to that. And that way, if you become incapacitated, your spouse will be able to take control of the accounts. And when you pass away, they're just going to go directly to your spouse if that's what your trust dictates, and they'll have control over them and then can be distributed out to your other beneficiaries after you both pass away. So joint accounts, bank accounts, checking accounts, savings accounts, brokerage accounts, all of those kinds of joint accounts, those are things that we would typically advise putting inside of a revocable living trust. And if for some reason there's a need to keep those assets separate, so let's say that you had some really highly appreciated stock within one spouse's brokerage account, and you did want to, potentially create some issues around basis and the assets, then we can draft into the trust that asset will be considered a separate asset, even though it's part of the trust. So there are ways to control within the trust document itself whether an asset is considered a joint individual asset. So all those types of things go in that bucket. We want to put as much into that bucket as we can so that we can ensure seamless management and transition of the assets if something happens to you. And it's particularly important in managing effectively for spouses. Now, lastly, vehicles. We don't normally suggest putting those into a trust. There are pretty simple transfer mechanisms through the DMV that will allow for the transfer of an automobile upon the death of the owner. Exceptions to that might be some sort of collection of cars if you have collectible vehicles, or if you have a particular valuable vehicle, there might be a need to put it into the trust. But with respect to normal everyday driving vehicles, we don't recommend putting those into the trust because they're pretty simple to transfer after someone passes away without too much fuss and muss. So understanding these nuances in how assets should be held are really important to making sure that your trust is tailored effectively to meet your specific needs and goals and to avoid some of the common pitfalls that happen in estate planning. So if you're setting up a trust or you're revising your estate plan and you need some tailored advice on how to handle your assets, we're here to help. So visit our website or contact us directly to schedule a personalized consultation and start your estate planning journey with confidence. Thanks for tuning into this video. Don't forget to subscribe for more practical advice on estate planning and asset management. Click our logo to subscribe and check out our playlist on trusts for more detailed information.